This thing to an open here. As you know, I'm the mayor here. My name is Clint Scherf. We have councilors up here representing. We're going to have a presentation that's going to be facilitated by our city manager, Aaron Kubik here, and we are all adults in this room. I hope that we can all act with decorum and give everybody a voice. There will be question and answer period at the end, or answer period for your questions that you've submitted. We will get to that as timely as we possibly can. And this session is very educational, and it's for your guys' benefit, and it should bring this state law back full circle to how it actually directly affects our city of Grants Pass. And with that, I'm going to hand it over to Aaron.
Thank you, Mayor, Council, members of the public. Thank you for being here tonight. My name is Aaron Kubik. I'm the city manager. And like the mayor mentioned, we're hoping that with this presentation and then the opportunity for you to submit questions, we'll all in this room have a better understanding of some of the limitations and the struggles that we've been having. I know council is just as frustrated as probably many of you here in this community with some of the things that we've had to implement and things we've had to do. And I think, and we're hoping that by the end of this evening, you'll have a better understanding of some of those challenges, and maybe collectively we can come up with some proactive solutions moving forward. My presentation is going to hit on a couple of things before we get to the questions, just so you have a general framework and background legally on what we have to do and why. I'm going to talk about how we got here, the questions, and then we're going to have questions and answers where you'll have an opportunity to submit questions to our finance director and our city recorder in the back there. We have a number of questions that have already been submitted. I'm going to go through those. I have those on the screen. There may be duplicates, so you may have a question that you wrote. It may be worded a little different, but if it's something, if it's what we have on the board, we'll just ask it on there. If you have any new questions, we'll add those to the questions. I'll be getting questions, and I'll be asking them, and we'll get those answers for you. So, and then we're going to follow up. The mayor's going to conclude with next steps and where we're headed. So I'm going to get right into it. I'd like to talk about the history, going from the federal cases to Oregon law, touch on House Bill 3115, which is really why we're here today primarily, which is turned into ORS, which is Oregon Revised Statutes 195, 500 through 530. And then what are some of the unanswered questions to where we are trying to implement this new state law? So when did it all start and how did we get here? It really started back in 2019. Some of you might be familiar with this case. It's Martin versus Boise. There was a case, Martin versus Boise, where there was a lawsuit. Boise was stated to have criminally been punishing the homeless people for sitting, lying, sleeping in public spaces because they had nowhere else to go, and they were sued for a violation of the 8th Amendment, punishing them for the unavailable consequence of being human. So Boise had codes similar to what a lot of cities had throughout the nation on the books, and it was deemed that that was unconstitutional based on the 8th Amendment because you were punishing people that had no other place to go. In 2022-2023 came our famous lawsuit, Johnson versus Grants Pass, where ours was basically an expansion of the Boise case. It added also a couple of provisions, and one of those primary ones is not only is it criminally and civilly a violation of the 8th Amendment to punish homeless persons for sleeping, lying, or taking rudimentary protections. So that's one of the additions that our case did, is people have the ability to stay warm and dry. So that's where hence tents came into play. So what these two cases basically set up is they started a standard for what is built into House Bill 3115, is it started to define what are time, place, and manner restrictions that can be imposed to people resting in public spaces. Well, the city of Grants Pass felt as though it was inappropriate and it was not in accordance with the 8th Amendment, so we appealed that. We appealed that to the Ninth Circuit Court. The Ninth Circuit Court ruled in favor of Johnson, and we appealed it to the United States Supreme Court. We argued that it's not a violation under the 8th Amendment for us to adhere to local ordinances that regulate time, place, and manner in resting in public spaces. So the outcome of that is, I'm happy to say, we did win the Supreme Court case. It was in the news, it was throughout the nation. I can tell you when I went to conferences or I went on vacation or something and I was anywhere but Oregon, they're like, hey, you're from Grants Pass? Way to go. And so the nation as a whole was very pleased with what we did. And I can tell you it was not easy. For over 4 years, our police officers, our parks municipal workers, so many people that were involved in this process of making sure that we are adhering to the injunction that we had to hold, which was basically imposed time, place, and manner regulations from the court system, changed the way we had to provide services to the community and to people visiting the parks and to how we enforce our own rules. And I can't say enough and compliment enough my colleagues that worked through this whole process across the realm. There was a lot of pressure, and we were able to maintain good, clean standing and win that Supreme Court case because we had great legal representation, and we have a great group of colleagues and a great group of policymakers that stood strong for what was right. So, can we celebrate now? We are able to state, every state in the United States, the Supreme Court said, you can set up rules, your own rules, to regulate where people can rest. Sounds like a good idea, but, along comes the state of Oregon. In their wisdom, they were watching our struggles when it came to Johnson versus Grants Pass, and they were very much aware of Martin Boise. In their wisdom, they thought it was appropriate and a good thing for every city in the state of Oregon to have time, place, and manner regulations like the city of Grants Pass had during our injunction. So they implemented what was called House Bill 3115, which stated that every city has to, if you're going to regulate time, place, and manner, you have to have time, place. What it states is if you are going to regulate resting in public spaces, you have to establish time, place, and manner regulations. We are the only state in the union that has this requirement. So what does House Bill 3115 basically say? It says that local governments may still regulate time, place, and manner of camping or sleeping in public spaces. However, any such regulation must be objectively reasonable as applied to people experiencing homelessness. The law requires cities to ensure their ordinances do not criminalize the mere act of being homeless, whether no shelter is available. And objectively reasonable is in parentheses there because that's something I'll touch on throughout these slides, and we'll probably touch on through a number of your questions. House Bill 3115, which ultimately turned out to be Oregon Revised Statutes 195, 500 through 530, regulates three things: car camping, property removal, and time, place, and manner restrictions. So I'm going to touch on all three of those. Car camping, what's regulated? Cities can regulate car camping for overnight car camping. Where is it regulated? State law says it's regulated on both public and private property. How is it regulated? Through time, place, and manner regulations. And if you are going to have car camping in an approved parking lot, you must also provide toilets, hand washing, and trash disposal. And this is for individuals only experiencing homelessness, not for the KOA traveler that's going from one place to another. You can implement reasonable standards of regulation, such as the maximum number of cars per site. Oregon law also requires cities to develop a policy that recognizes the social problems and nature of homeless individuals camping in public property to ensure the most humane treatment for removal of homeless individuals from camping sites on public property. I'll take that another step further. When it comes to their property that they have, their campsite, the city must provide 72 hours notice before removing that property from an established campsite. We also have to publish that and provide that notice in English and Spanish. We also have to provide the notice in all entrances to the campsite. We have to include where unclaimed property will be stored with phone numbers. And we have to inform local social service agencies where the notices are posted. When we remove the property, if the property is removed after a 72 hours notice, we also have to do a few extra things according to state law. We have to store those materials for 30 days. So we have a storage location for items left by the unhoused by these locations that we've provided 72 hours notice. They have to be in a facility located in the same community. Items of no value or utility or that are unsanitary can ultimately be discarded. Weapons, controlled substances, or contraband are given to the police, and we have to make it reasonably available for claiming. It has to be at a location that's relatively easy. After 30 days, if they don't claim the material, we can dispose or donate that unwanted material. There are only a few exceptions to this rule. It's a pretty hard-standing rule. If there is illegal activities associated with that campsite, we can remove it. If there's some kind of exceptional emergency, there's a flood, some kind of natural disaster, or other things that can happen, or if there's actually a funeral, that campsite would be in the way, we can remove the campsite immediately without providing the 72 hours notice. So the third item, the time, place, and manner restrictions with regards to ORS. This is where it gets a little confusing and gets more complicated. What is regulated? So Oregon state law states that if we're going to regulate resting in public spaces, our other option is if we didn't implement ORS 195, it would mean individuals can rest wherever they would like in any public location. City Council recognizes that that's likely an unlikely and unfavorable policy to have, so we have to try to come up with some form of objectively reasonable standards to regulate resting in public spaces. We have to, and we can have regulations associated with sitting, lying, sleeping, and because of our lawsuit that was built into 3115, the ability for people to keep warm and dry, measures to survive outside. Where do we provide those regulations? Outdoors, on public lands and premises or buildings, and any property open to the public. How is it regulated? Through time, place, and manner regulations established in our codes. Who's regulated are those individuals experiencing homelessness. And what is the standard for regulation? Again, this is where objectively reasonable comes into play. Objectively reasonable standards can be implemented. The problem is there's no statutory definition for what objectively reasonable is. We don't know what objectively reasonable is. Our council might think we know what objectively reasonable is. Each one of you might have an objectively reasonable definition. No one's wrong, no one's right, because nothing's been defined. We also, when it comes to our standards, need to take a look at the totality of the circumstances associated with the situation. For instance, what services are provided? Why is that individual in a homeless situation? (3115), ever since its implementation, has had a lot of controversy associated with it. So much so that the League of Oregon Cities and multiple cities throughout the state of Oregon have made a push to try to make some changes to 3115 through repeal or reform. So this year in the state legislature, we tried to push a bill, Senate Bill 593, to provide legislative clarity so we can sort of all be on the same page and have a better understanding of what objectively reasonable is. If not there, we ultimately end up finding the definition of objectively reasonable through 27 circuit courts. So the legislative clarity that we tried to seek within Senate Bill 593 were 4 items. We needed local control and flexibility. We sought for legal clarity and enforcement authority. We also sought public safety and environmental protection. And we were trying to encourage proactive solutions and the opportunity to untie the hands of municipalities throughout the state of Oregon. To go into some more detail with that, local control and flexibility. Repealing House Bill 3115 would restore the local autonomy to craft ordinances tailored to specific community challenges. The city of Grants Pass is much different than the city of Bend, which is much different than the city of Hermiston. We're all different. City councils should have the authority as a policy board to adopt what's objectively reasonable for their own community. A one-size objectively reasonable standards would limit municipalities' ability to respond to urgent and localized concerns. Second item with regards to Senate Bill 593, which we were trying to fix, was legal clarity and enforcement authority. The term objectively reasonable lacks legal precision and invites litigation, making enforcement unpredictable and burdensome for cities trying to maintain safe public spaces. It also sought to remove some vague statutory language with regards to totality of circumstances. Public safety and environmental protection was another key point for Senate Bill 593 that we saw with regards to deficiencies in Senate Bill 3115. Unmanaged camping in sensitive areas such as rivers, parks, and schools poses risks to public health, safety, and the environment. A repeal would allow for more decisive action to maintain community standards while exploring safe harbor options for individuals experiencing homelessness. And the fourth main point with Senate Bill 593 to help address the 3115 is encourage proactive solutions to create some safe harbor shelter spaces or sanction alternatives voluntarily. So I want to touch on some of those specific things. For instance, totality of circumstances, and what does that mean, and why we're trying to fix that, because every community is different. To specific challenges. As I mentioned in the previous slide, 3115 is set up to create lawsuits and invites lawsuits upon cities. What we are trying to do, and I'll mention that, is to try to create an opportunity where cities can respond without being sued. And then we're looking for some safe harbor clarification. Totality of circumstances. What we mean by that is the impact of the laws on persons experiencing homelessness are different. The impacts on other users of public property is much different. The availability of county and city services and resources are different. You take a look at Kaiser and Salem. They have a 3-county cohort where they work together on unhoused and homeless situations. They have a lot of resources that they pool together between counties and cities. Look at Josephine County. Grants Pass is the county seat. And our resources are much different than those in Salem and those in Portland. That needs to be taken into consideration, and House Bill 3115 does not do that. Also, the intended use of public property. What is the intended use of your parks? Is it for people to be able to rest? Is it for people to be able to recreate? Is it for people to be able to what? When it comes to safe harbor provisions, what we are really trying to do in Senate Bill 593 is get to some common ground that we can bank on, that we know is safe and defensible. For instance, no camping between 7 a.m. and 7 p.m. No camping at city halls or county courthouses or police stations or playgrounds or flood zones or 300 feet from business entrances, or how about 500 feet from shelters or 1,000 feet from childcare facilities. Getting some kind of commonality there to where we can have something in place that's defensible and it doesn't open the cities up for lawsuits. We wanted that clarity. And then going back to the specific challenge required, it would require, and we were hoping to have it required to where if someone was going to sue the city, they need to give us at least 90 days before that person brought suit. That would provide an opportunity in writing for the city to respond to that, maybe address a code that may need to be addressed before just going straight to a lawsuit. Unfortunately, at the state level, Senate Bill 593 fell on deaf ears. And there was not an appetite for our state to reconsider any repeal or reform of 3115. That was not without great effort. One of the top 9 legislative priorities for the League of Oregon Cities was reform or repeal of House Bill 3115. The intentions of 3115 may have been good when we were going through the injunction in our Supreme Court appeal. From a state level, they may have thought that that was a great idea for everyone to have a requirement to do time, place, and manner regulations. But the way it was implemented has been disastrous to communities throughout the state of Oregon. And we're definitely feeling it here in Grants Pass. Without clarity at the legislative level, unfortunately, communities now are left to seek clarity through the judicial system. One of the unfortunate things about that is if you look at the state map on the judicial system, we've got a number of different judicial courts throughout the state of Oregon. Each one of those with the potential authority of determining what's objectively reasonable for that community. And when you think about it, you're talking about one judge, one individual that's going to tell the whole community what's objectively reasonable versus an elected officials that you've elected to determine what's objectively reasonable in your community. We are currently in a lawsuit. You probably know that. The Disability Rights of Oregon versus Grants Pass. So in August 2024, we implemented time, place, and manner ordinance. Our time, place, and manner ordinance, and we did this after we won the Supreme Court case. By now, in 2024, every other city had time, place, and manner regulations. Ours was frozen because we couldn't do anything because we were in a lawsuit until we won or lost the Supreme Court case. We won, but unfortunately, that didn't impact the state of Oregon because of 3115. So we had to implement our own time, place, and manner regulations. We did. We stated that there's no camping on public property such as parks, sidewalks, streets, alleyways, pedestrian entrances, or vehicle entrances at any time. By resolution, council could designate campsites, 2 sites with a total space of approximately 150 tent sites, and we had camping for up to 7 days. Now, originally when we implemented this, and I think if some of you were here and you remembered that when we won the Supreme Court case, and as soon as we implemented this ordinance, it was probably the most successful ordinance that I've seen adopted and implemented in the history of Grants Pass. Within 1 week, because of the dedicated municipal service workers, the dedicated police, fire, and all of our crews and all of my colleagues, we had our parks cleaned up within 1 week. Within 1 week, our parks changed because we were able to enforce our own resting in public spaces ordinances. It was a huge success. It took courage by our council to adopt something like that, and it took trained professionals and a great group of people to do so with little to no conflict. We got our parks cleaned up. We originally started by naming 2 sites. We had a J Street site. We had a 6th and A Street site that ultimately turned to the 7th Street site. And we said they were resting sites. We still today call them resting sites. It's something the mayor is very strongly about and council about. They are resting sites. They're not camping sites. We originally established those sites after we won the Supreme Court case, and we built in our ordinances to allow them to rest overnight. Council, about 2 or 3 months into it, decided to expand the camping into the J Street, and also in doing so expand the resting time to 7 days. That means no matter what our hours are, how many days we provide, we still, after those days are done, likely have to still give 72 hours notice. So if we had 7 days and they were there over 7 days, we would then provide a 72 hours notice after the 7 days. So they have over a week for resting. In January 2025, we closed J Street as a designated campsite. We also, at that same time, took the remaining campsites and limited it again back to 5 p.m. to 7 a.m., which we originally had when we first won the Supreme Court case. In January 30th, a complaint for declaratory and injunction relief occurred from Disability Rights of Oregon. That claim then went to a temporary restraining order to us on February 18th. In February, we opened a 2nd site in response to this, which is what you see now, 6th and A, and we still have our 7th Street site. And then in February, we also extended camping to 4 days, and we allow them to rest 24 hours per day. And then after the 4 days, we need to give 72 hours notice. We can provide 72 hours notice. That's all state law, and that's a requirement by the state of Oregon, not a choice by city council. So the temporary restraining order and preliminary injunction, the allegation is that the ordinance was not objectively reasonable. Disability Rights of Oregon said that the way we were handling our campsites, the way we were handling enforcement of individuals resting in public spaces is not objectively reasonable. Why? Because we immediately reduced the number of potential campsites from 150 to 90. And also they decided that our sites were not ADA accessible. At the temporary restraining order stage, time restrictions to only night camping alleged to be unreasonable, particularly as it relates to applying with ADA. While the temporary injunction was in place, which it still is in place to this day, Grants Pass cannot cite, arrest, detain, issue fines, or otherwise prosecute any persons for camping on public property not described below. Or we cannot remove a campsite that is not clearly abandoned. Permitted camping for 1 week is considered objectively reasonable. Grants Pass can only enforce its time, place, and manner ordinance in the following locations. We are able to allow for our enforcement in sidewalks, streets, alleyways, pedestrian entrances, vehicle entrances, Riverside Park, and Reinhardt Volunteer Park. This is what our local judge has defined as objectively reasonable regulations that we have to follow. Currently, right now, the guidance that we've gotten on why we were not objectively reasonable, because we did an unexplained reduction in size of our campsites, because there's a question on whether or not we're in compliance with ADA. We only allowed night camping at the time, and there was a pretext for disappearing homeless. And those were the 4 items that were listed in the lawsuit. So what do we think we know now and where we're going? We know that prohibiting on sidewalks, roads, and entrances is permissible. We have a local judge that says that's objectively reasonable. Prohibiting in particular parks is permissible. Designated camping locations must be ADA accessible. Limited camping to only nighttime hours is not permissible. We need to show our work. If we're going to make changes to our codes and ordinances, it's highly recommended that we make sure we have a true roadmap that shows the decisions and why we made those decisions. And we must be mindful of pretextual appearances. What questions remain unanswered that we're still asking right now? This is what our policy board and city council is asking currently right now, and you're probably asking yourselves. How many camping sites does the city have to provide? We don't know. We don't know what that is. The state has not defined it, and the court system has not defined it. If a city doesn't identify any specific camping sites, only places you can't camp, do the non-designated sites have to be ADA accessible? So if you just list where you can't go, all the other public spaces, do they have to be ADA accessible? We don't know. What does ADA accessible include? Just hard surface pathways or what? Where does ADA start and where does it stop? Does the 72-hour notice need to be posted in advance of any allowed camping deadline? Say, for instance, you have an opportunity where you allow people to rest for 96 hours. Can you concurrently also post the 72 hours so the times run at the same time? Or can you go ahead, or do you have to wait until the 96 is up before you post the 72? Again, not fully defined. What type of evidence, weighing factors, is needed before a city can close a campsite and still be considered objectively reasonable? If a city has a camping site open or a service provided to the unhoused, and they make a policy decision to close it down or modify it, is that objectively reasonable? That's not defined. In our situation, it was defined as if we made a change and there was a reduction, that's not objectively reasonable. We're not alone. There are many other cities, and I'm going to highlight a couple that we've learned some lessons from also, just so you have an idea that reinforces some of the experiences that we're dealing with. And I can tell you, in talking with people throughout the state, this is not over. And ultimately, it may not be over for the city of Grants Pass either, because we are the tip of the spear. I can tell you when we implemented our time, place, and manner regulations after we won the Supreme Court case, we weren't doing anything any majorly different than any other city in the state of Oregon. But people are watching the city of Grants Pass. In Portland, Multnomah County Circuit Court decision dealing with Portland's time, place, and manner ordinance. Portland adopted one in 2023. It prohibited camping between 8 a.m. and 8 p.m. So it said you cannot erect tents or camp during the daytime. Restrictions on where and how people can rest during 8 p.m. and 8 a.m. For example, no tents during daylight hours, but bedding was permitted. They also provided a map of where camping was prohibited. Portland's ordinance was challenged. It was challenged based on a couple of things. One, not permitting camping during the day is not objectively reasonable. Night camping is not as safe as day camping. Some people experiencing homelessness have jobs at night. When do they get to sleep? Only designating where camping is prohibited as opposed to where camping is permitted is not objectively reasonable. That was the challenge of Portland's ordinance. It went to a court. There was a temporary restraining order granted due to a prohibition of daytime camping. Portland saw the writing on the wall, and they basically just repealed their ordinance altogether and decided not to fight it. So from this case, what do we not know? How many hours or days does a city have to provide a person who is homeless to camp for the regulation to be objectively reasonable? Hasn't been defined. Is a city required to identify both where camping is prohibited and where it is permitted for the ordinance to be objectively reasonable? By that first court injunction, sort of sounds like it, but it's not defined. Another one, Malheur versus Curry County. This is a pending federal case. Here's the facts on this. Disabled individuals and others were camping on public property. There was a deficient 72-hour notice posted for people to be removed, and a new notice was promised. The county leased property to adjacent private property owner. The private property owner directed the sheriff to remove the campers within the same period as the deficient notice. Deputies offered an opportunity to help the disabled homeless individual to relocate, and they ultimately did not relocate. What happened with this, and let me explain this a little better, is the county, after having an issue with people resting on public property, just went around and did like a dollar lease to a private property owner and said, here. Then the private property owner said, please give this person 72 hours notice. There was a lawsuit filed for that action of that county. The lawsuit claims that the actions are not reasonable under ADA. More time than 72 hours is required for those individuals with ADA issues. Did not define how many hours is objectively reasonable. The county's lease to privately owned property violated the state law and is a pretext for not complying with House Bill 3115 and for removing homeless individuals from the county. What did we learn from this one? Well, we've got some unanswered questions still. Can a city transfer a known camping site to a private ownership to remove the property from 3115 requirements? Sounds like we can't, but it's truly not defined. Is the 72-hour notice requirement in the ORS reasonable given ADA requirements? Didn't get any further direction from that. What type of accommodations does a local government have to give a person and to whom the ADA is applicable when making them vacate a campsite? That's a tough one. Who's the one that ultimately says that person has an ADA complaint? And how do you monitor that? What does a local government need to do to avoid allegations of pretext being at play? So I'm almost done giving you a background. And I'm not sure if you're as frustrated and a little blurry on what the laws are as I am right now, but you might be. And we're probably sharing the same feelings at the moment. I could tell you this, I'll end on a positive. What have we learned? What do we know? Because there's a lot of stuff that we don't know, as I've mentioned in each one of those slides. Every time something goes to a circuit court, we get more unanswered questions. When we try to get clarification at the state level, they don't want to make any clarifications. So how can we move forward, and what have we learned? Community conversations should occur before enacting or updating any kind of time, place, and manner ordinances. I can tell you this council is very interested in that. We've had multiple conversations about having public comment and opportunity for that. This is one of those first steps. We need to consider all impacts to all people and all city programs and services. Following the lead of cities who have been deemed reasonable, courts or the Oregon Law Center. There are a few cities that have been challenged and have upheld their codes. Medford and Bend are two of those that have had a challenge and been ruled in the city favor. Be mindful of appearing as anti-homeless. Factor in ADA in identifying designated campsite locations. Factor in ADA in campsite removal processes. Seriously consider not prohibiting daytime camping. Consider creating a map of where camping is permitted and maybe not permitted. Consult with legal counsel and insurance, we do all the time, and show our work to explain our reasons. Don't leave the court with wiggle room. So one of the key pieces is decision-making moving forward when it comes to policy. We want to make sure we have a roadmap. You know, in grade school and junior high and high school, you had to show your work and come up with the answer. You might know what the answer is, but if you don't show your work, you didn't get the full points for it. We need to show our work, because if we get sued and we have to go to court again, we want to say, look, judge, this is what we did and this is why. And that'll help us be more defensible. So, that concludes my presentation to sort of give you some background. I can tell you probably have even more questions or even different questions now than you did when you came here. You thought, okay, I'm going to ask this question. Oh, wait a second. Now I've got this question. Great. I hope you do. We have a number of questions which I'm going to pull up on the screen. Probably about 2 pages worth that people have submitted in advance, and we appreciate those people that submitted in advance. We're going to get to all those questions, and we're going to get to all of your questions. As I go through these questions and we go through some of the answers, make sure to get a 3x5 card out. If we haven't addressed your question, make sure to get it back there to our finance officer or our city recorder. They'll move those up to me so we can get your questions answered. You may find out that some of these questions that we have are probably ones that you've written down, so you don't have to submit those. You may have written yours in a certain way, or someone may have submitted theirs in a certain way. We've already seen like 5 or 7 questions of the same question but worded differently. We've just tried to take just a general wording of that one question. So you might not find your exact verbiage, but hopefully we'll get the spirit of what your question is. We also received a few questions that don't have any subject matter associated with House Bill 3115. Maybe it has to do with levels of services provided for the unhoused or something along those lines. Those are questions we will not be addressing tonight. We need to stay focused because of your time, because of council's time, and because of the information we're providing today from this learning and listening session. We're focusing on giving everyone a good foundation and a good background on legislatively and legally what our boundaries are, or what our boundaries aren't. We just don't know. So with that, I am going to pull up the questions. Okay. We have these in a few different categories, and they're just suggested categories, but we're going to start with understanding House Bill 3115, legal and legislative impacts. The first one is, what is the overall requirements for a shelter to meet House Bill 3115 requirements? I could probably guess this one, but
hey, Aaron, I'm just gonna butt in. Could you make that a little bit bigger on the screen? Is you able to do that? Because I'm having trouble seeing it here, and maybe the audience is having a little trouble. That's much better. Thank you, sir.
Yep, you got it. Thank you, Mayor. What is the overall requirements for a shelter to meet House Bill 3115 requirements? Well, I can tell you from a shelter perspective, depending on what you mean by shelter, that's not defined. We don't know. As I've told you, in every court case, it's different. You get judges ruling differently in every community. and the state of Oregon has not defined what that is. We know that ADA seems to be a common thread amongst all of those, so we know that ADA is something that needs to be addressed. But how you interpret ADA is a whole nother story. So there is not any true, fully defined measures or requirements associated with shelters. It varies and has not been defined. Do you have any additions to that?
I do, actually. I'd also note that the shelter itself is probably not required to meet the standards of House Bill 3115. It's the city's regulations that are bound by that. So if the shelter is provided by the city, then yes, we would have to make sure that it was city-sponsored time, place, and manner regulations. But if it's a nonprofit or a private entity, maybe not. And the way it might work out for us is that if a separate shelter provides sufficient accommodations so that it becomes objectively reasonable for the city to prohibit completely resting on city property, that's great, and then we would be able to do that. But otherwise, we're still bound by the city having those regulations that are objectively reasonable, not the shelter itself.
Thank you. You'll likely hear from Stephanie quite a bit tonight as she's trying to define this from a legal perspective. To meet 3115 requirements, what is the required target size, person-wise, for any managed shelter? It's a great question. We really didn't have a target size until our recent court case where we're in right now, and we have our injunction that's put into place, and the judge mentioned that we had to have resting sites that would allow for up to 150 people. So currently, right now, for the city of Grants Pass, that 150 number is what the local judge has determined as objectively reasonable. But that doesn't stand for other communities in the state of Oregon, and there is not a true standard for that the state has defined or that communities have defined. Okay, wow, I got that one. Sweet. What does House Bill 3115 require if persons are trespassed out of or refuse to go to a managed shelter? I don't think I'm going to touch that one. Stephanie, you want that one?
A little bit. House Bill 3115 doesn't require anything as it relates to that. It just says that our regulations have to be objectively reasonable from the perspective of someone that is experiencing homelessness. So it's at this point just a case-by-case analysis and whether or not it's going to be reasonable under those particular circumstances. There isn't any case law out there that defines that yet. I'm expecting there probably will be, but as of right now, there's no requirements from the House bill, and we just have to try to figure it out as we go.
So I'm going to keep you on. Oh, Mary,
Can I add into that? Because Stephanie said a very, very prominent two words together. There is no case law for the arguing HB 3115. So that's why there's a lot of questions that can't be answered, because normally, I'm not going to speak for a lawyer, but what I've been told by our lawyers is you can go back into case history and you can look at what's been done in that specific case on that specific topic, and then you can kind of go in a direction. Since there is no case law on this specific House Bill 3115, we are the first to the table. Aaron keeps saying we're the tip of the spear. So you have to get that in your head that there is a lot of questions that we can't answer because even the judicial system can't answer it. So I think hopefully that brings it back a little bit home, but I'm sorry to interrupt.
Mayor, no worries. Thank you. So Stephanie, to carry that on, is there any kind of clarity with regards to where the sites have to be located inside the city, outside the city, in order for it to be claimed as for the city?
There's not. It's going to have to be, again, that objectively reasonable standard, and you're going to get really tired of hearing those words. But if it's too difficult, what the court in that particular case would look at is how difficult is it to, for a person experiencing homelessness to get services, find work, obtain necessities like food and water. How difficult are those things depending on how far it is from the city? So it's, again, objectively reasonable with regard to persons experiencing homelessness.
Thank you. This is maybe another one, Stephanie, for you and or the chief, but is there a 24-hour law somewhere? I know we've got the 72-hour law that I mentioned, but is there a 24-hour law?
There is not. The current code language prohibits resting overnight in city parks. That's the recent amendments that we made last week. Prior to that, there was some 24-hour language in the code. That was removed because it was actually a more difficult standard to enforce. It was a prohibition against placing materials in such a manner that they appeared to be there for like they were going to be longer than 24 hours. So we cleaned it up by saying overnight. But it's been, I believe that Actually, I think there may have been at one point a 24-hour on how long one of the resting sites was open, but it's currently 96. So there's nothing in existence for the city regarding 24 hours.
Thank you. So this question came from someone that knows that objectively reasonable is extremely vague. They're asking if there's any recourse for us to basically sue the state.
Probably not at this point. The recourse at this point is to try to get the law revised or repealed, which is what LOC is trying to do. That's the easiest way to get it done. It's actually probably faster too, despite the process that it's been through this legislative session. It's going to be easier to try to work with the legislature rather than to get the court to weigh in. The court's weighing in is a multi-year process.
Thank you. Just to break up the monotony of the voice, I'll answer this next one because I think I got this one. Yes, we could be sued again. We can make some changes to our code and we could be sued again, which could ultimately result in another injunction. Would it help the city's legal standing should there be future litigation if residents were polled to gain consensus on these matters? Reasonable individuals, reasonable time determined, etc. So yes, that would help. Like I mentioned, showing your work. The more that we can show our work as a city, the more that we have these type of forums, we get these kind of questions, and we'll have, the mayor's going to talk about another forum we're going to have at the end of the meeting here. The more we do that, we do our homework, the better opportunity it creates for us to defend ourselves and our decisions at the court level. Oh, thank you. All right, so let's see. Another question in this category. Any updates on the current injunction? Where are we currently at? Question mark. Stephanie, take it away.
We are in discussions with what the next steps are going to be.
So currently we are still under the injunction.
Correct. Under the injunction, trying to figure out what the next step will be.
So we can tell you that we have made positive progress in trying to address the issues that the judge has called out in the injunction. Say, for instance, the amount of inventory we have for resting, the code changes that were adopted 2 weeks ago. We now then have to reapproach the other side and the court to look at the injunction, the removal injunction, or the court case. The timing of that, though, is something that I don't think Stephanie feels comfortable with or myself feel comfortable with, because that is out of our control. So I don't have the ability to tell you when that is. But I can tell you we're actively pursuing that, and we have been since the day after council adopted the code. We've been actively taking as much opportunity to move that forward as possible. Under camping and resting sites, how does 3115 affect our current campsites? If a managed shelter were put into place, would the city be able to close these campsites down? I've heard this question multiple times.
This is the best lawyer answer I can give, which is it depends. It's going to depend on what the shelter capacity is, what the barriers for that shelter are. The city would likely be able to close most, if not all, of the current resting sites, but if that managed shelter were available, we would have to evaluate whether it meets all of our needs. And if not, some level of city property may still be necessary to use for some level of site. And we may have to develop some kind of an exception process if the shelter's not a reasonable solution for all involved. But it's going to be significantly less than what we currently have today.
Thank you. As I understand that the law allows for cities to designate resting sites, if a city chose not to designate resting sites, can they still regulate where homeless can and cannot camp? That's another Stephanie question.
If we choose to regulate where a homeless person can rest, we have to have places where they can do so. We can choose not to regulate at all, but then every place is fair game. We can specify certain off-limits places with the remaining public property available for resting, or we can designate certain places where you can be with everywhere else off-limits. Right now, we're doing the latter. We've designated 4 resting sites, and all other locations are prohibited.
So this sort of plays right in along with the next question too. It's like they're playing off each other there. Number 11 is, can the city leave some parks open and close some parks to camping? And the answer is yes. That would be a potential option for council to consider when it comes to time, place, and manner. What is the minimum requirement for housing? Tents. What is the minimum required spacing between tents?
The city code that was just adopted has it as an 8x8 spatial footprint for a site with a 3-foot buffer around each site. That's the way we've defined it at this point.
It appears other cities have had a low barrier site without lawsuits. Is a low barrier site possible without a no barrier site? I could try to take it too, but we'll see what you got.
Possibly, yes, but as Aaron mentioned earlier, the city of Grants Pass is under a microscope, and we've got more scrutiny than other cities, so it's a question of risk tolerance for the city council on this one. No barrier is going to be the safest to avoid litigation, but if the city declines to provide a no barrier option, there may be additional lawsuits. Whether those are going to be successful is a different question, because we don't have any case law that tells us one way or another. But we could potentially just have low barrier and no barrier.
And I think the reason why there's that lack of clarity is because truly we don't know on some of these things. That really hasn't been challenged in any other community. I think a lot of the other communities have low barrier, and so that seems to be a standard. But to address this question specifically, it has not been defined by the state or by the court system yet. Would a central location and program that meets the needs of the homeless and the standards of 3115 be weighed more favorably by the courts than a resting site?
It probably depends on the court, but it's likely that a central location and program that meets needs and legal requirements would be viewed more favorably. The reason behind that is because 195.500 says that cities have to have a policy recognizing the social nature of the problem and implementing to ensure the most humane treatment. So if you have a program that provides services, it's going to be viewed as more humane and more of a recognition of that social nature.
Okay, thank you. Under shelter locations, community impact and alternatives, some questions that were submitted in advance. Why not relocate the homeless back to the parks over the bridge or select a location on the outskirts of town instead of downtown? Well, there's a number of policy decisions you can make. You could choose, like we mentioned before, I think you sort of answered before, there's a number of options. If you choose certain parks, you'd have to also label certain parks for and that would allow camping and not allow camping. You have to try to determine in the court's eyes what would be objectively reasonable. And I think that's, again, an unknown. Just as if you were to choose, take all of our park system and say, okay, what are you going to choose? You would have to come up with reasonable spaces for individuals to rest, according to House Bill 3115.
Can I add a little bit to that too?
Yeah.
So if you realistically think about the way that we've been, putting out this information, the current lawsuit is talking about making sure that the sites are ADA accessible. So realistically, if, in my mind, as a layman, I'm not a legal person, but if you allow people to go back into, you sacrifice a park or two for that to be the resting areas, will you get another lawsuit coming by because the grass is not ADA accessible? It's just kind of a stupid thing to ask, but that could be a situation. And I think we've lived through a few years where our community didn't want to give up any parks. So we are where we are today. Go ahead, Aaron.
Okay, thank you. Let's see. I'm not sure if this is quite, how is it that Ashland and other cities, Oregon cities, do not have open air, low barrier homeless camps in the middle of their cities? Well, there are a number of communities that have resting sites within central business district areas and industrial areas, next to or adjacent to residential areas. So I don't know if that's a fully accurate statement, but it's based on the policy decisions of the elected officials and where they deem an appropriate site would be for people to rest in relation to House Bill 3115. For the city of Grants Pass, I think we were looking at trying to quickly address the issue and get out of the injunction and do some things, and we chose some sites that were determined to be the least impact to the community, but also had the ability to move on quickly with city-owned pieces of property that were currently owned by the city. How long is temporary, and was this stated at the April meeting? Please answer with a specific date. So temporary. So it is, we've been saying that our resting sites are temporary in nature, and they are temporary in nature, but we don't know what that date of the temporary is. We don't know when this ultimate injunction or lawsuit will be over, and if and when something else will follow. So they are temporary in nature. They are not permanent. And the sites that we've deemed so far through the history of the city having designated sites have been temporary. But there is not a sunset on those temporary sites. If the city supports a managed facility like the Stepping Stone Stabilization Center, how do we convince the homeless it's best for them? Can they be forced to go? Stephanie?
I think that depends on the injunction. Once the city's code can be enforced and there's a place where it's objectively reasonable for a person experiencing homelessness to be, such as a facility, public property can be either completely or mostly off limits for resting. The question is going to be on whether that managed facility has rules that mean it does not alleviate the burden on the city to provide space. So we'll get there as much as we can, but it's going to be a matter of just closing the parks when we can, which means we need to be able to enforce our code.
Shouldn't public camping bans still apply to those who are only temporarily in the city or refusing shelter based on personal lifestyle choices, not necessity?
The laws apply equally to everyone as long as they are objectively reasonable with regard to persons experiencing homelessness. And I guess the only thing I can say is, again, unfortunately, we can't enforce those laws because of the injunction, so it looks like we don't have them.
Next question, what will the city of Grants Pass do when the next lawsuit is filed? I don't think myself or Stephanie can answer that because we don't know if there will be one filed, and we don't know what the context of that lawsuit might be if it is filed. I still don't understand why the city hasn't accepted Medford's offer for a tour to show that what they've accomplished. Well, I can tell you, and I'm happy to say that I think a lot of the X team, some of my colleagues, and the majority of council sitting here today have all toured Medford's facilities and have a good understanding of what they've implemented, along with other neighboring communities, for instance, Bend and Roseburg also, and what they've implemented in order to address 3115 and they're unhoused in their community. So we have definitely done our homework when it comes to that. Another homework question that was submitted here from the audience was, does the city council consult and work through the city attorney and other staff before making a policy decision? And I can tell you, yes, we do. If and when an alternate site plan is finished, will we be able to keep all homeless resting out of the city public areas?
It depends, maybe, hopefully. I know that the way that the ordinance was written, it says that all parks, and that would include what you would normally think of as parks as well as other public spaces, so the courtyard out there around public buildings, those would be closed to camping. You can't be there overnight, period. It does say unless it's an authorized resting site, and what would happen if we had a managed site that took enough burden off of the city to provide, we'd be able to just close those down and just have 0 authorized resting sites. That would be the end goal. So they would still be allowed if we ever needed them, but hopefully we wouldn't have to have them implemented.
Okay, let's see, here's a question under population concerns and perceptions. Are the homeless population numbers increasing? Camps are full and they still wander the streets. How many will be too many before real action is taken? So, I don't know about the last part of that question, but is the homeless population numbers increasing? I don't know if maybe the chief has any kind of response to that, what you're seeing out there in the streets.
First of all, I wanted to say hello to everybody. My name is Warren Hensman. I'm the Chief of Police here at the City of Grants Pass, and I just wanted to be known that I am a 24/7 chief, and if you guys ever want to come in contact with me, give me a call, have a chat about this after this session. It's an open invitation. Please give me a call, and I'm happy to chat about this with you all over in my office or wherever the case may be. But I can speak to this anecdotally. I can tell you we've been living in this environment since I joined the department in 2019. And my guys typically tell me the number sits around 90 to 100 homeless, transient, unhoused type people that we typically see in our community. Are we going to ebb and flow with what's happened over the years? Absolutely, 100%. I've heard talks and conversations about people being bussed into town. There's no evidence of that whatsoever. But are people coming to our town? We're probably yes. People still have a right to travel. We have those freedoms to go from state to state and city to city. Is that happening here? Probably the answer is yes. Our laws are less restrictive than other laws. So I think it is reasonable to say that people will go to locations where it is easier for them to behave in a certain way. And I wanted to just make it clear, when I talk about populations, we are always neutral at the police department, and we treat every single person with dignity and respect, and we only manage behavior. And we have a lot of bad behavior in our community that we've been managing for years, and it continues. We continue to have to manage that, and we make a lot of arrests. So anecdotally speaking, it just goes up and down. And I will answer how many will be too many before re-election is taken. I can't answer that number, but I can assure the community that we run call to call to call and take significant action against bad behavior. We have a lot of restrictions and we are handcuffed in a lot of ways, but we also have to follow the rules. So it may not satisfy everybody's need, but we have to follow the laws, and our team do a really fine job in managing behavior problems around our community, and we arrest a lot of people. You might be surprised, a community of our size, we're arresting over 50 people a week. That's just arrests. That's not everything else we deal with. So I just wanted to share that.
Thank you, Chief. I do want to make one clarification too on that. When the Chief was talking about our laws are less restrictive, our laws technically that council has implemented and that we adopted are not any different than a number of the cities in the state of Oregon. What's less restrictive right now is this injunction that we're working under, something that the court has said we have to work under. That's what's less restrictive. The injunction during the 4 years of the Supreme Court case was less restrictive than the majority of any other time, place, and manner regulation in the state of Oregon. That's unfortunately what we've been living under for the past almost 5 years, is not upon our decision to implement, but either through the court, it's been through the court system, they've implemented less restrictive ordinances and codes and laws than council has wanted and desired to do.
Can I just piggyback on that too, Aaron? And thanks for that clarification. That's a very important point. Because we have to manage case law as well as laws that are Oregon Revised Statute and municipal ordinance as well. There was a question earlier on about trespassing, but it also goes to, it speaks to what ordinances we already have in place and how we manage them. So if you commit an ordinance violation twice in a city park, for example, or one criminal offense, you're trespassed from that park for 30 days. And we do that often. That also includes the resting sites. So I wanted to add that to the conversation.
Thank you, Chief. Question number 3, what are you doing to discourage more homeless from coming here? I don't even think that's, we're not taking action to discourage or encourage homeless coming here. Question number 25, will the city release data on how many individuals actually decline available shelter, and if so, for what reasons, so the public can see whether refusal, not lack of options, is driving enforcement limits? I know we do a lot of data. We're a data-driven department and community. And Chief, do you want to try to address that at all? Do you have anything to add to that?
I was sidetracked on my notes. Can you just remind me which question we're on?
Question number 25. Part of it is we don't have a
So the manager mentioned data-driven. We're incredibly data-driven. To give you some kind of an idea of what we manage about 33,000 to 36,000 calls for service just from citizens alone. So when you put that into perspective, we're only authorized 57 cops and we're 11 square miles. That does not include proactive work. So as we kind of walk this new journey, we're having an incredible time just keeping police officers here, hiring new cops, so recruitment and retention can be difficult. But as far as data, we're always keeping an eye on data. But we're also restricted by budget constraints, and we've had to cut certain positions. One of the positions over the years that was cut was a crime analyst position, but we did bring back that in a part-time capacity, and we're starting to ramp that position up where that individual is getting a good amount of training so she can provide the additional data that I need to be successful here in the city.
Stephanie, you have anything to add, or you're good? Okay. Under public involvement, advocacy, and funding, in the April meeting, we were encouraged to contact the governor. Isn't that your job as council or city leadership? Yes, it is. I think it's everyone's job in this room. I can tell you that I have had a personal conversation with the governor about some of the Senate bills that have come through and how they've affected our local community. So as individuals up here on the dais, along with other staff members, along with League of Oregon Cities. I'm on the board of League of Oregon Cities, and that's one of the things we've been championing is reform and repeal of 3115. It takes a community, and that's why I think council is encouraging you. The more contact and information that they receive from their constituents, which you are, the better it is. So please, we definitely encourage you to continue to do that. I know this city council and other city councils throughout the state of Oregon are still pushing for reform or repeal 3115. What is the city's position on the growing financial burden of homelessness programs, especially when the approach leans towards providing unlimited shelter access without behavior expectations? So that is truly, I think, a policy discussion and decision, and there is a financial burden for homelessness. I can tell you that I think for the fiscal year 26 budget, JC might have that number in his head. It's around 300 and something, 300, huh? $240,000 we have budgeted for unhoused services, right?
Sorry, $371,000.
371,000. Ah, see, I knew it was 300 something. Thank you. So the costs are going up, and it's throughout. I've talked to many other city council members, mayors, city managers. Communities are individually spending millions of dollars on this issue, and that in itself raises questions, I think, on is it best served individually like that, or should we look at how we can maybe do this together as a state to address these issues. If it's a budget issue, why not consider a temporary tax to address homelessness? Could we create a public survey to get opinions on this? So we could do some kind of fee, homelessness fee. We could do a levy, like we have a public safety levy for homeless services, to gather resources to create some kind of program. I think the last question here is important, though. Before anything like that was to happen, I would imagine, and the mayor can chime in if he wants, there would be a huge amount of public input and outreach in order for anything like that to even be considered.
Yeah, I'll weigh in on that. It could be an avenue that council does decide to champion and go forth. I don't think the community has an appetite for it, so it is kind of a hard road to deal with. But, you know, again, it kind of comes back to the questions that we can't answer. It's another question we can't answer. We can't answer how long the community is going to have to fund temporary resting sites and keep putting money towards homelessness services. It's just not questions that we can fully answer until until HB 3115 is fully litigated and we have some more definitions. Kind of brings me back full circle to, yes, I was one of the people that championed the community to reach out to public officials at the state level, at the federal level, is because if you as a community can bring attention to this matter, to point out some of the trials and tribulations that we have in defining this state law, HB 3115, I think it benefits the community in the long run. And, you know, some of these challenges that we have that you're going to hear over and over tonight is the fact that we do have to abide by laws. We have to abide by state law. This is a state law. So, you know, as myself and I think a number of council members up here have reached out to government officials at a higher level and asked for help and pleaded. I mean, I've gone up to the governor's office on bended knee asking for support and help. And, you know, if we have a group, if we have the numbers to ask for that, it might not fall on deaf ears.
Thank you, Mayor.
Just want to piggyback on what the mayor said. Finance Director here with the City of Grants Pass, J.C. Rowley. I think the key issue to look at when we're looking at funding is we don't have a particular solution yet. So what are we funding? So the nexus to what we would be charging the community needs to be defined before we choose a funding mechanism to even ask of the community.
Whoa, you don't go anywhere. There's one more question. Get back here. Is the state or federal government contributing a meaningful support to offset the growing costs of compliance with 3115, or are local taxpayers expected to bear this burden alone?
So currently, we do not have direct support from either the state or federal government. However, I will say there have been small grants and things before the final ruling of HB 3115. We did get some Department of Administrative Services money that helped fund the new on-tract facility and was awarded for homelessness and houselessness. We do keep our eyes open for those kinds of opportunities to ensure that we can make those programs and or projects come to fruition.
Thank you, the person behind the green screen there in the back. So are there any other cities that want to band together? I think we talked about this. There are other cities together working together to try to look at repeal or reform on 3115. Under criminal justice, what staffing issues at the county DA's office are preventing prosecution of drug crimes? Are there any police barriers to enforcement? Chief?
So this is a great question because it's very difficult for all of us to understand, and me included. So Senate Bill 48 created a matrix on when you can hold people in custody for a period of time. But there's also legislation that's already been passed, specifically with the recriminalization, because remember we were under I tried to forget about it. Thank you for reminding me of Measure 110. But unfortunately, the DA's hands are tied with certain arrests of low-level possession. So it takes more than, I don't have the matrix with me, but it takes a couple of arrests before somebody can be detained for what we might consider a significant amount of time. With that said, though, the bigger problem, in my opinion, is the staffing level in general to prosecute thoroughly all crimes, because our county is overwhelmed with higher level cases like Measure 11 cases. So your murder, your rapes, your robberies, your aggravated assaults. There's significant violent crime in our community that our DA's office has to prioritize. So there's that as well. Myself included, when I say our team, we're very frustrated at what might appear to be a revolving door at the jail, for example. Our folks arrest a lot of people, like I said, but a lot of times the charging decision is not what I would want. in a perfect world, the accountability for people to be prosecuted is important to me, and it's important to you, and I know that. But there's only so many DAs at the DA's office to prosecute cases. And when you have a county that has a significant amount of murder suspects locked up just across the street, you can see how the prioritization of casework must be implemented. But that is not to say that we do not arrest people regularly for possession controlled substance, even the most minor substance possession. For example, I walked across here a couple of days ago, maybe a week ago, with a couple of my colleagues, and there was a fella getting ready to smoke fentanyl right in front of us. Didn't even recognize we were there. So he went straight to jail. But he was probably released fairly quickly because there are much higher priority cases that the DA's office needs to manage. So that is just something to share when it comes to the criminal justice system in our county. Also, too, this actually correlates to what's happening in our jail. The sheriff only has so many sheriff's deputies to manage the jail. So there are plenty of occasions where people are released on what's called a bar release, which is a beyond available resource release. I would much prefer that does not happen. But the sheriff has to make decisions on how to manage the jail efficiently and effectively to make sure everybody within his facility are being held accountable safely. So I didn't want to go into any more detail about that, but there is a lot of contributing factors to what we all sometimes refer to as the revolving door of justice. Also, too, for everybody, as a reminder, the Grants Pass Police Department are the only ones on duty 24/7 in this county. And I say this over and over again. State police go off duty in the early hours of the morning, and so, too, does our Sheriff's Department. And the only ones up at night are the Grants Pass Police Department, keeping an eye on things. So we have a lot of issues that we have to work through, and it's not just this unhoused problem. It's a behavior problem and it's a justice problem in general. And we've already started conversations about municipal courts, and we'll see where that goes as a policy decision with the council. But this was a good opportunity for me to share that as well.
Thank you, Chief. What steps is the city taking to ensure that prioritizing the needs of the unhoused individuals do not come at the expense of public safety, park usability, and neighborhood stability? Stephanie, I think I'm going to have you take that one.
I think the city has prioritized doing what is required by the court to get the injunction lifted, because that's what it's going to take to allow the city to enforce the laws that are there to protect public safety and hopefully move the homeless individuals from the parks. So in order to get those things back, we have to get the injunction lifted. To get the injunction lifted, we had to add additional resting sites, and hopefully we can move forward.
Thank you. We sort of addressed the first part of 33, but maybe the second part, I know the chief has done some efforts with regards to safeguards or additional actions that we put into place to help with how our resting sites affect nearby neighborhoods.
Yeah, this is tricky. We were having a conversation earlier about low barrier and no barrier, and it's no surprise for me to tell you that no barrier does not work. We live it every single day, and we see a significant amount of behavioral problems across the street and then over by the PD. We do everything we possibly can to maintain public safety in this community. Have we reevaluated our enforcement strategy over the last several weeks? Yeah, absolutely. More people are going to jail. There are additional video surveillance cameras up across the street. And they really are great for after the fact, and we're solving crimes after the fact, and we're holding those people accountable. Are our folks trying to reevaluate their basic route north and south, east and west? Yes. Do we have a community response team with people that are hired specifically to work the camps and the parks? The answer is yes, and they continue to be in our parks every single day. But I mentioned staffing issues before. It's hard to keep that team fully staffed with, I think, an adequate amount officers. So what I've done is I've asked our patrol teams, when they hit a certain level of officers on duty, to reassign an officer to that community response team. In fact, it happened today. There's only so many people on duty, but our patrol staff had a level that we feel comfortable giving a body to the community response team, and then they spend all day in the parks. So for example, we're getting ready for Boatnik, so we have to make sure Baker Park is cleared out, and Riverside Park and Riverside West, all that kind of stuff that we continue to do. But also too, there are several other parks throughout the community that are being improperly utilized, let's say that. So they have to go down there and manage that as well. The reality is there's only so many cops out there, and it's really difficult to manage crime in general. And we've had our hands full over the weekend. We put out a couple of press releases this morning. We had an incident up at Ogle Park where an individual was arrested for robbery, one, and a couple of issues, menacing with a machete and things like that. And the fact that that rolls off my tongue like it's normal, that's disappointing to even hear myself say that out loud. And then we had a sex abuse case down at Baker Park. These are just a couple of small examples from the weekend. We're incredibly busy, but we're dedicated, and please know that we're dedicated. Sometimes I might have a look on my face of exhaustion and frustration, and I think that's okay to be tired and frustrated, but please know that you have a dedicated team of men and women that give it 100% every single day, and they love this community, and they're not going anywhere, and they continue to go out there and provide quality service. So I just wanted to add that to the conversation as well.
Thank you, Chief. And I'm just going to keep you on the hot spot here with question number 34. You've created, and your leadership has created, some great programs to help divert people and get them off the streets. Can you talk a little bit about that?
Yeah, absolutely. So I think a lot of people in the community want us to figure out the root cause of crime, and that's what we should do. Sometimes there's easy fixes where we can take people to jail and it solves the problem for 12 hours, but ultimately is that the root cause of what we're trying to accomplish. The Sobering Center was established before I got here, and it was under Bill Landis's leadership. And the Sobering Center is quite a blessing to this community, where we can put people in sobering versus the jail, because once we put you into the jail, then you're part of the criminal justice system. And it's much easier to essentially deflect somebody to sobering, and you stay in sobering for several hours. But the good news about sobering is you have a team of dedicated people that will navigate you towards services. Now, you can't force those services down somebody's throat, but for the people that go to sobering, a lot of them go there regularly. So eventually you get sick and tired of being asked to, hey, do you want to do this? Do you want to do this? Do you want to do this? And a lot of times they eventually will say yes, AKA comply to some sort of a treatment option. But when I came on board, I wanted to establish case management within the PD. So embedded case managers within our PD that are the service providers that understand addiction, mental health, treatment, different social services that we're not capable of doing. The professional police officer nowadays is sometimes expected to do a service provider's work along with the police officer role, and we just can't do that. So I'm proud to say that we've had amazing partnership with Options for Southern Oregon for several years. And when I came on board, we were able to bring on a case manager permanently at the PD. And she works hand in hand with our community response team, myself included. I provide plenty of referrals. Well, I won't say plenty, but I do provide referrals as well, and our officers. And she is able to help a lot of people along the way. And recently, we were able to add a second case manager from Options for Southern Oregon to our PD. And now we have both Lisa and Crystal who work with our team, and they help a lot of people behind the scenes walk towards addiction treatment and housing, and something as simple as getting your driver's license or figuring out how to get my social security number or a P.O. box for mail, helping people walk through through something that's very difficult for them, because we tend to forget when you've lived a life of homelessness for many years, something as simple as remembering to brush your teeth is a chore. And I don't want to minimize anybody. That's the last thing I want to do. But we have these case managers there that are sincerely supporting people and also people in this community on their journey. But we've also, I think, taken it one step further. People continue to overdose on not as much heroin, but definitely fentanyl. Meth seems to be having a comeback, so we have a lot of issues with meth and fentanyl in general, and a lot of people are overdosing. And some people do die. Regardless of what anybody believes, anything we can do to stop somebody from dying is very important to me. So we have a partnership with Adapt Integrated Health, where every single overdose incident in Grants Pass, we have a dispatch center that will dispatch a recovery mentor to that call. Now, we will make sure that that scene is safe before the recovery mentor comes on board. But then when the scene is safe, the recovery mentor will arrive and try to encourage that individual to walk towards treatment. It's voluntary, they don't have to, but that's something that we do to get to the root cause of these problems. And we've also started the deflection program, so probably late December, early January. And this is all kind of hand in foot with ballot measure 110 reform. And we weren't mandated by the legislature to do a deflection program, but we've always been doing some sort of deflection for many years. So it was kind of simple for us to say, well, yeah, of course we're going to do that. And I think we have one of the best deflection programs in Oregon. And for example, we don't write citations in abeyance, and what that means is give you a ticket for possession controlled substance, and if you fail in deflection, then it goes to the court system. No, we just decide to take you directly to the sobering center and put you in the deflection. And we've had some great successes already through deflection, and some not so great, not so very successful through deflection. But any way you look at it is if somebody is off controlled substances for a period of time, the reality is they're not behaving badly because they're trying to get themselves well. So that's important, but also too, if we can continue to beat that drum and folks recognize that I can go in a different direction and help myself, which in turn helps the community, that's something that we support 100%. But I will tell you this, that I monitor what's going on in this community quite intently. And recently, and I'm not going to say I discourage deflection, that's not the case, but recently I have encouraged more arrest versus deflection, because you've probably noticed the inordinate amount of violent crime that's been happening. It seems like every other week, or not every other week, every other day, there's a stabbing or something heinous happening. And sometimes the root cause of a lot of problems in communities are drug addiction, period. And so we've kind of taken a bit of a firmer approach when it comes to possession controlled substance, and there's a lot of people going to jail right now. So we'll even out, and then we'll start to redirect people towards deflection. And I kind of compared and contrasted it to if we have a school teacher in the audience, you probably know that sometimes you're a little firmer in the classroom and sometimes you're probably a little bit more lenient, but you're really just looking for that sweet spot in the middle when it comes to enforcement of your classroom, or in my world, enforcement of behavioral problems in our community. So that just shares a little bit what we've been doing for years now and how to support services.
Thank you, Chief. One of the questions is, what are we doing to protect our businesses, children, and community from some of these issues? And I think you addressed that with the last two responses, so appreciate that. Another question from the audience is, when will we be moving these campsites? We mentioned it was temporary, so we don't have a date on when they will actually be moved. Let's see. So here's one. This could be for Stephanie. Okay, they sort of two the same ones. So what are the legal consequences for those drug addicts that refuse help? Can they be made to leave Grants Pass? And there was sort of another question by someone else is, We can vacate them from, trespass them from the parks and public spaces. Can we trespass them from the city?
Doubtful. I think my answer would probably be no. There may be a way to do it, but I think in the long run, that would just end up in more litigation, unless they're actually, I guess the chief mentioned that if you violate certain ordinances, you can be trespassed from specific parks. So if they get themselves trespassed from every park, that would then prohibit them from being in public spaces. I don't think we can just outright kick somebody out of a city. I've only ever seen something like that once, and it was in Minnesota, and it was a judge that did it. So I don't think we could do it.
Thank you. I did have a question about jail operations, but that would be more for the sheriff. What are we doing proactively to prevent drugs from entering our city? It's not quite addressed. That's a question that we could be taken offline, like the chief said. That's he can answer that.
Could I just hit that real quick, Aaron? Unless you didn't.
Well, I just want to make sure that we're clear that we're focusing on 3115.
Absolutely. And just a quick shout out to our Rogue Area Drug Enforcement team. We have somebody embedded with the DEA, and whoever asked that question should give me a call tomorrow.
Will all our parks codes and rules be 100% enforced by law enforcement? Yes, within our restrictions that we have. If we have an injunction, whatever we want, like the chief said, and you totally saw and heard the passion in his voice, we want 100% enforce our local codes and rules. No? Let's see. Okay, this is my last written question I've got here. What happens if we defy the courts? What happens if we got a court ruling? What if we say, you know what? We're not going to do it.
Likely be held in contempt, and it would be the city, but it would also potentially be the individual officers, and we don't want to put our officers and their licenses at risk. It doesn't look good for anybody to be held in contempt by the courts, and the law is the law, so we follow it. But like we're trying to do now, we find the way to get compliant with the law so that we can, in fact, enforce our code.
Thank you. So that concludes questions that were submitted and questions from you here in the public who visited. I want to first say thank you for taking the time to spend time with us today to hopefully learn a little bit, and we learned a little bit by having you ask those questions. I also want to thank this council, because this council is the one that spearheaded this meeting. It's because of them. They want to definitely hear from you. They want to start to have that dialogue and that conversation to make sure we're all on the same page with the information. So Mayor and Council, thank you very much for putting this together, and I greatly appreciate that. With that, I'm going to turn it over to and staff. Thank you for the great answers. Greatly appreciate it. And for helping with the questions back there. Thank you very much. And Mayor, I'm going to turn over to you.
Thank you. I do thank you all for coming out and listening to us and providing us with some questions. Hopefully that we gave you some information tonight to digest. As Aaron said, the council's intention is for this to be the first start of a series of forums within the public. We thought it'd be best to educate, to bring the public up to speed, to be more educated on what we are actually dealing with and how this state law actually directly affects the city of Grants Pass. We are still underneath a temporary injunction, so our law enforcement doesn't have the ability to enforce some of the regulations in places right now. We have shored up our code, so when that temporary injunction is lifted, that we will be able to enforce more regulations within our city. As well as we are underneath this temporary injunction, so we're trying to roll this series of town halls out in a timely manner, but we also want to make sure that we're very cognizant of everything that we say in a public venture is basically defining and detailing what the city is doing and what the city can and cannot do, instead of actually being targeted on certain topics that could possibly be used against us in furthering this injunction. So hopefully that you guys got a bit of an education out of this. I know that you might walk away with still some more questions. Most of the council and myself, as well as city manager and his staff, do take questions via email, phone calls, and everything for the public. We try to reach out and try to respond as quickly and best that we possibly can. And we try to be as engaged with the public as we possibly can. So with that, we do have we have a council workshop coming up where we're going to be looking at exploring options of putting a grant together to actually fund something in the near future to kind of alleviate and placate and maybe protect us from future lawsuits. So keep your eyes open. Most of you guys here in this audience definitely watch us on everything that we do, which is great, and I love the community involvement. And I guess I'll end with thank you again for coming out, and have a good evening.